What is up? We are back with more gun news here on John Crump News, where we talk about news every day-ish, maybe. Rich will be joining us in a second, but let's go ahead and roll that intro. Thank you for joining me, Rich. People have been writing me asking where you've been.
Busy. It's tough being unemployed.
Yeah, I've been busy with day job stuff.
I may have a day job also.
Oh, awesome.
I didn't talk to you about that, but
congratulations. Breaking news, Rich have a day job. All right, this case is Firearms Policy Coalition versus Bondi, and it's out of the Northern District of Texas, the Fort Worth Division, and the judge on this case is the Honorable Reed O'Connor. And anytime I see Reed O'Connor's name on a court case, I rejoice.
It's as good as Clarence Thomas. You think they hang out? You think they're going to like picnics and barbecues together?
Probably not. I know who picnic and barbecue he does go to though. Although I've never been to a barbecue where he's been at. All right. Yeah, my aunt is Clarence Thomas's neighbor, and they barbecue sometime. Even though I haven't been over there for that, but whatever. All right. So both this deals with the banning of guns in post offices. Short, to the point. Both the plaintiff and defendants both filed for motion of summary judgment. The DOJ and the DOJ had their motion for summary judgment denied, and the plaintiffs had their motion for summary judgment granted. This is on the merits of the case, so this is a little bit better. So let's go ahead and read through this. It's only 17 pages, so it's relatively short. Some of their decisions can get up to hundreds of pages.
Okay, background. Post offices are a fixture in the routine lives of many Texans who rely on the Postal Service to, among other things, receive mail, process money orders, apply for passports. Despite this, individuals are barred from carrying firearms for self-defense in post office and on postal property by two provisions of federal law.
All right, so it's going to go over the two provisions. We're not going to really even do this. Just go to the plaintiffs. But two provisions says, whatever.
Plaintiffs are two Texas citizens, Gavin Pate and George Mandry, and two nonprofit membership associations, FPC and the SAF. Both individual plaintiffs and members of FPC and SAF are licensed to carry firearms in Texas and desire to carry their firearms for self-defense while visiting the post office, as opposed to leaving them in the car where they can be stolen. They refrained from doing so out of fear of violating the aforementioned provisions of federal law. In turn, plaintiffs assert that this infringes on their Second Amendment rights, which it does. Plaintiffs brought this suit June 18, 2024 against Pamela Bondi in her official capacity as Attorney General of the United States, defendant or the government, asking the court to scroll up. Enjoin enforcement of 18 U.S.C. 930A and 939 CFR 232.1 subsection 1 to the extent that they bar the possession and carriage of firearms in post offices and official property. Plaintiffs filed their motion for summary judgment on October 21st, 2024, and the government filed its combined motion for summary judgment in opposition to the plaintiff's motion for summary judgment on November 24th, 2024. Plaintiffs then filed their combined reply and response in opposition on December 18th, 2024. The government filed its reply, blah, nobody cares. We doing legal standard?
Well, yeah, go ahead, do it.
Okay, a movant is entitled to summary judgment if by the pleadings and evidence it can show that there is no genuine dispute as to any material fact, and the movant is entitled to judgment as a matter of law, cite whatever. Summary judgment is appropriate where the only issue before the court is a pure question of law. Great summary. And a Second Amendment challenge can be facial or as applied. United States.
Let's talk about what that facial means. Like everything's being attacked. Like the law itself is facially unconstitutional, which means the law is banned. An as applied challenge is as applied to the movement, the people that are filing the lawsuit.
The parties of the suit.
To the parties that are parties to the lawsuit.
So that could be in many cases that we've discussed here. It could be GOA members. It could be Cargill and GOA members.
FPC members.
Yeah,
since this is their case.
So okay, let's see. A Second Amendment challenge can be a facial or as applied. Blah. A facial challenge is the most difficult challenge to mount successfully because it requires the challenger to establish that no set of circumstances exist under which the challenged regulation would be valid. And they're talking Rahimi. An as applied challenge asks whether a law, though constitutional in some circumstances, is nonetheless unconstitutional as applied.
So basically, it's a lot harder to get a facial challenge, to win a facial challenge, just because the extent of a facial challenge is wow. Nice. They're right. I'm not going to. That's pretty funny. Keep on going.
Plaintiffs do not specify whether they are bringing a facial or as applied challenge. They only ask the court to find unconstitutional and join 18 U.S.C. 930A and 39 CFR 232.1, subsection 1, to the extent they bar possession and carriage of firearms in post office and on postal property. Because the regulations at issue cover more than just firearms, including explosives and other dangerous weapons, the court will evaluate the previous mentioned laws as applied to plaintiffs carrying firearms in ordinary post office. See New York State Pistol Rifle Association, the Bruin decision.
Yeah, basically the judge doesn't want to touch, can you carry a pipe bomb into a post office, or
is it a bearable arm? Is it a bearable arm, Crump? Come on.
Yeah.
All right. So the judge is based, but not that based.
He says, well, he's not going to address that at all. He's not saying
right, because that would clearly get appealed. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. U.S. Constitutional Amendment 2. When evaluating the Second Amendment claims, courts must first determine whether the Second Amendment's plain text covers an individual conduct. Bruin. Constitution presumptively protects that conduct, and the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. Only if a firearm regulation is consistent with the nation's historical tradition may a court conclude that the individual, where did I lose?
Individual's conduct falls outside the Second Amendment's unqualified command. I did that to stop you. Remember, I'm not going to go too much into the Bruin standard, but just brief overview, because I do this a lot. The courts consider people members of the people, or at least Americans, at least go beyond this, that are 18 years of age, which is the age of the majority. And then bearable arms are bearable arms. Guns, handguns, whatever, are bearable arms. And therefore, since the plaintiffs are part of the people and the arms are bearable, then their conduct is presumptively constitutional. And then it moves to the second state. The second step, where the burden falls on the state to prove that a law is consistent with the nation's tradition and history of firearms regulations. They do that by showing historical analogs from the founding era, which most people consider to be 1791, the ratification date of the Second Amendment, although some courts have made an argument that it's the ratification date of the 14th Amendment,
14th Amendment.
1868.
Yeah.
So keep on going.
Massive middle finger. When determining whether the regulation is consistent with the nation's historical tradition, the appropriate analysis involves considering whether the challenged regulation is consistent with principles that underpin our regulatory tradition, Rahimi, while a modern regulation need not be a dead ringer, or a historical twin for regulations be at the founding, they must be analogous enough to pass constitutional muster.
That was said in Rahimi, by the way.
This involves asking both why and how a regulation burdens an individual's Second Amendment rights. If laws at the founding regulated firearm use to address particular problems, that will be a strong indicator that contemporary laws imposing similar restrictions for similar reasons are permissible. However, the law may fail to pass constitutional muster if it regulates arms bearing to an extent beyond what was done at the founding.
But basically, you can go up to what they're doing at the founding, but you cannot cross that.
The court determines that both 18 U.S.C. 930A and 39 CFR 232.1 Section 1 are inconsistent with the principles that underpins the nation's regulatory tradition. Thus, they are unconstitutional as applied to carrying firearms inside an ordinary post office or post office property. Now, as applied means, who does it apply to?
As applied means it's going to apply to SAF members, FPC members, and the plaintiffs.
I get to open carry in a post office. And you do too if you join one of these organizations.
Yeah, I wouldn't want to fight that though. Because it's going to take a while before that doesn't get before people realize what this exactly says. And I mean, you'll get off, yeah, but
I'll get arrested and screw up my day.
Yeah,
and might have to fight to get my firearm back. So don't go running to your post office today.
Yeah, a lot of post offices try, they try to say that you weren't even allowed to have any guns on post office property, even if you.
Well, I just throw mine in the middle of the street before I go in, and then pick it up later.
Yeah,
that's not post office, or I'll dig a hole in a schoolyard.
All right, let's keep on going.
Generally, when the government regulates arms-bearing conduct, as when the government regulates other constitutional rights, it bears the burden to justify its regulation. Bruin. Here, the government asserts that under Bruin, plaintiffs bear the burden of rebutting the presumption that banning firearms in all government buildings is constitutional. The government misreads the law.
They did, because it's the government's responsibility to prove after the plaintiff step one of Bruin is satisfied that they have to get a plaintiff. Step two. The reason why the government tried to do that, I believe, is because there is no historical analogs that they can use.
In the District of Columbia versus Heller, and I like Dick, the Supreme Court made clear that the long-standing laws forbidding the carry of firearms in sensitive places such as schools and government buildings are valid restrictions on bearing arms. In McDonald versus Chicago, the court reiterated their holding did not cast doubt on such long-standing regulatory measures, including laws forbidding carrying firearms in sensitive places such as schools and government buildings. And if you don't mind scrolling up a little more, yeah. The government argues that Bruin reaffirmed sensitive places restrictions that There is a presumption that federal buildings are sensitive places. According to the government, contends that the burden should fall on the plaintiffs to rebut the presumption of constitutionally, and show that the post office and postal properties are non-sensitive.
All right, stop right there. What the government's argument was that, hey, the post office is part of the government, which it is, but it kind of is an outlier.
Isn't? Don't they have to have a constitutional amendment because the post office was mentioned in the Constitution to make it not a government agency, which they kind of did without a constitutional amendment?
Yeah, it's kind of a gray area.
It's a quasi-government agency. So, but this is incorrect as far as I understand. Bruin didn't say, "Hey, you can't make everything a sensitive place."
Yeah, and they're gonna reference McWarry here, who is a channel watcher here. So, hi.
Okay, the government cites.
I wonder where they find all these plaintiffs at.
I wonder. I wonder.
They all seem to be my channel viewers for some reason.
Chana member. The government cites to this court's opinion in McCrory v. Garland to support its position, case law. The court indeed observed that nothing in the Bruin majority disturbs Heller or McDonald, and that Bruin majority therefore seems to acknowledge the facial constitutionality of regimes requiring background checks and attendant waiting periods.
McQuarrie dealt with enhanced background checks for those under 21 as put forth through John Cornyn's Bipartisan Safer Communities Act,
which was a resolution, not a law. When the Fifth Circuit affirmed, it noted that Bruin continued to distinguish the treatment of prohibitions on keeping and bearing and ancillary firearm regulations such as background checks preceding sale. It emphasized that Bruin requires a historical showing by the government when the Second Amendment plain text covers an individual's conduct, and that the plain text covers the plaintiff's right to keep and bear arms. And it explicitly said that sensitive place laws are likely captured by the plain text of the Second Amendment. They directly impact the right to bear. Therefore, they are likely subject to Bruin's historical analysis.
So basically, he's throwing it back on the government.
Both, I'm not even going to cite the laws, prohibit carrying of firearms in post offices and on post office property. This is clearly the type of regulation covered in the plain text of the Second Amendment, not ancillary regulation like the regulation at issue in McCrory.
So basically, they're saying the under 21 enhanced background thing was not a direct ancillary regulation. It wasn't, but this is definitely a proper main regulation, basic.
United States v. Alum, the Fifth Circuit further explored the constitutionality of sensitive place restrictions. In Allen, the constitutionality of a statute that prohibited both possession of a firearm on school grounds and within a 1,000-foot buffer zone around school grounds was at issue, although school grounds and government buildings are quintessential examples of sensitive places. According to Heller, the Fifth Circuit determined that the Second Amendment's plain text covers the defendant's conduct keeping a rifle in his car ostensibly for self-defense, and thus a Bruin analysis is required. The Fifth Circuit ultimately found the law constitutional only because it was consistent with the principles that underpin the regulatory tradition at 3 ID 300, whatever. In a footnote, the circuit explained that it did not need to address the sensitive place doctrine to resolve Allman, and reiterated McRory's assertion that sensitive place laws are likely subject to Bruin historical analysis. Considering Fifth Circuit's rationale in McRory and Allman, and because 930 blah target the keeping and bearing of arms, the court finds that the government burden shifting argument is incorrect. Accordingly, because possessing a firearm for self-defense within a post office or on post office property is an activity that falls within the plain text of the Second Amendment. The government must show that banning firearms within the post office or on post office property is consistent with the nation's historical tradition of firearm regulation. Bro it. Amen, brother. Thank you, Clarence Thomas. May you reign forever. Constitutional rights are established when the scope they were understood to have when the people adopted them. The Second Amendment was ratified in 1791.
Yeah.
Not later.
So we're gonna skip all this right here. So basically, what the judge is saying is he's not buying into the 1868 thing. He's buying into 1791, which is probably the right time frame. The reason why 1868 is used a lot by liberal judges
because they want it to be that way
is because that was during Reconstruction era where a bunch of Jim Crow laws passed and there were a lot more gun restrictions, so they picked the racist period.
Because the white Democrats wanted to lynch the freed slaves and have them not shoot back at them.
Correct. They use that. If you ever read through any of these, most of the historical analogs that they use from those periods are racist gun laws.
Racist AF, yes. And to answer the person, IVN 79, yes, I do like Dick Heller. He's a friend of mine.
All right, keep on going.
Post offices predate the founding of the United States. The first official mail service began in the American colonies in 1639. Office of the Historian Corporate Affairs of the United States Postal Service and American History 2, 2025. Hereafter.
Basically, what he's saying is there were post offices back then and they didn't ban guns.
That's a great one. Our nation has grappled with threats to mail carriers in post offices since the founding in 1792. Congress has enacted a law which prescribed the punishment by death to any person who shall rob the mail or shall steal and take from, wow, that's rough, from or out of post office any letter or packet. A few years later in 1799, Congress sought to protect postal employees by punishing a robbery of a postal employee in which a dangerous weapon was used with death if the robbery was successful, or if it was unsuccessful, with public whipping or imprisonment. Wow. That the founders were acutely aware of threats to the post offices and postal employees, yet choose to criminalize the offending behavior rather than banning firearms outright is telling. Dang.
So basically, he goes through and like, hey, they could have done this very easily and they didn't do it.
Great points.
Therefore, the founders did not want guns to be banned at post offices, because if they did, they would have done it. This is not something like post offices isn't something new.
Right.
Post office is and he even gets into it a little bit later, because like 1972 was when they actually banned guns in post offices, which is way far away from the founding era. So much far away from the founding era that the government didn't even try to use that as a historical analog, because of it doesn't really work. The government did try to cite that pesky Northampton statute, which seems to be a statute that everyone...
Wait, hold on. Northampton, like that's in Virginia. Northampton, right?
No.
It's Long Island, with the Hamptons out on Long Island.
No, from 1328 in the UK. I want to have Stephen on to discuss that, because that gets brought up a lot. 1398. It's 1328.
So we're doing common law-ish? What's going on?
Yeah, common law. I mean, the government sounds like a sovereign citizen.
Reasoning by analogy, it is hard to see how post offices, while important, rise to the same level of importance or provide the same weighty government functions as legislative assemblies, polling places, and courthouses, absent a relatively similar historical analog. It is hard to envision that the founders would countenance, or in other words, consider banning firearms in the post office, particularly because they did not do so themselves. Thus, the
Yes.
government has not carried its burden.
Yeah. So let's go to the Hail Mary attempt because this is kind of funny.
That's great. That's the ultimate beatdown. In a Hail Mary attempt, the government argues that the Bruin analysis should not apply in this case because the constitutional dimensions are different here than in the Supreme Court's recent cases, namely because the government owns or at least leases the property at issue. It is insulated from the Second Amendment requirements by the Constitution's property clause and post office clause. The government cites a handful of cases to support its position, but none stand for the proposition that the government, as a property owner, can bypass parts of the Constitution it deems unfavorable. I guess you don't have free speech either at a post office.
What they try to argue basically is, hey, yeah, we're the government, but we're going to pretend like we're the private owners, like this is private business. We're just the owner of the private business. Therefore, private businesses can ban guns if they want, and we're going to just be a private business and ban guns. And the court said, yeah, that's not how it works.
Wow. This is congruent with Bruin's affirmation that the Second Amendment is not a second-class right. Amen, brother. Thank you, Clarence Thomas. A recent Third Circuit opinion recognized the same, holding that firearms restrictions affecting government property are subject to the same historical inquiry as other firearms regulations rather than a categorical carve-out. Coons versus Attorney General of New Jersey. The government cites one almost compelling Fifth Circuit case, which could be read to suggest that the property clause excuses firearm regulations under the Second Amendment. See whoever, but Dorson is an as unpublished pre-Bruin decision that was ultimately decided on the interest balancing grounds, a practice specifically repudiated by Bruin. Thank you, Thomas.
Yeah, so you can't use interest balancing. So they were trying to use a case. We're going to skip the rest.
They got smacked around hard.
They were trying to use a case that was pre-Bruin that was decided on interest balancing, which is not allowed under Bruin. So yeah. So basically, they grant the motion for summary judgment for the plaintiffs and tell the government to go pound sand.
Is there a stay on this for X amount of days?
Let's read through.
Okay. Remedy, having found in favor of the plaintiffs on the merits, the court must finally consider the proper remedy. Plaintiffs seek a declaration that 18 U.S.C. blah and 39 CFR blah are unconstitutional as applied to carrying firearms in the post office or on post office property, and a permanent injunction enjoining the government enforcing blah against the plaintiffs or their members with respect to the possession or carrying of firearms in post offices or on post office property, because plaintiffs have agreed to limit their relief to ordinary post offices not located in restricted areas like military bases or where the government provides armed security. The court likewise limits its remedies to ordinary post office declaratory relief. Plaintiffs are entitled to declaratory relief in this case under the declaratory relief judgment. A federal court may declare that the rights and other legal retaliations of any interest party seeking such declaration, whether or not further relief could be sought, USC blah, any such declaration shall have the force and effect of a final judgment or decree and shall be reviewable as such The declaratory judgment in this act, an act enabling an act is enabling act or whatever, which confers discretion on the courts rather than an absolute right upon the litigant, and citing case law. And the existence of another adequate remedy, such as vacatur of injunction, does not preclude declaratory judgment that this is otherwise appropriate. Thus, the court declares that 39 CFR blah is unconstitutional under the Second Amendment with respect to the plaintiffs and their members' possession and carrying of firearms inside of an ordinary United States post office or the surrounding post office property. An ordinary post office of the United States, defined as the United States Post Office, not located inside a military base, restricted access area, or federally owned or leased building, housing, government functions other than post office, in which carrying a firearm would otherwise be prohibited. 18 U.S.C. blah is unconstitutional under the Second Amendment, which, with respect to plaintiffs and their members' possession carrying firearms, same as the other thing, so we'll just keep going, in permanent injunctive relief. Plaintiffs are entitled permanent injunctive relief. A permanent injunction is a proper when plaintiffs prevails on the merits. There is no adequate remedy at law for the plaintiff's otherwise irreparable injury. The balance of harms favors the plaintiffs. An injunction would serve the public interest. And cite some case law. As explained earlier, this order plaintiffs satisfy the first requirement because they succeed on the merits of their Second Amendment claims. Regarding the remaining injunction factors, plaintiffs are suffering and will continue to suffer irreparable harm due to credible threats of enforcement, compliance costs, and chilling of constitutional rights. Likewise, the balance of the inequities and the public interest factors are the plaintiff's favor, and the government has not identified concrete injuries to counterbalance real harms facing plaintiffs, and there is no public interest in unlawful government action, skipping case law. Accordingly, having considered the arguments, evidence, and relevant law, the court holds that the relevant factors weigh in favor of entering a permanent injunction. Yes. Because plaintiffs carry their burden as to each of the permanent injunction factors. The court next addresses the scope of the injunction. When ordering equitable relief, the court is obligated to state specifically and reasonable detail the act or acts restrained or required under the injunction, skipping case law, the extent of the violation established, more case law, should be crafted to provide complete relief to the plaintiffs, and Mock v. Garland, case law. At the same time, the injunction should be no more burdensome to the defendant than necessary to provide complete relief to the plaintiffs, and it must be tailored to redress plaintiff's particular injury. Therefore, the court determines that the injunction focused on enforcement and implementation remains necessary to wholly redress the plaintiff's injuries. Here, declaratory relief is not enough without the additional protection that follows from the clarity. Could you scroll up, please? You scrolled the wrong way.
Oh,
Of permanent injunctive relief specified below. Thus, the court enjoins the government from the following actions against plaintiffs: interpreting or enforcing 39 CFR blah, these two laws that prohibited the plaintiffs and their members' possession from carrying firearms inside an ordinary USPS, postal property, or an ordinary post office, defined as post office. We already went through that. So yeah, you can't do these things. Conclusion: for the foregoing reasons, plaintiff's motion of summary judgment granted. Defendant's motion for summary judgment denied. So ordered. Signed, Reed O'Connor, Chief United States District Judge. So
you can.
Is this immediate?
Yes. If you're a member of FPC or SAF, you can open carry, but law enforcement probably don't know about the decision quite yet.
Yeah, that's just like, so in Florida, a case came out a couple of weeks ago, and it's like, hey, you can open carry in Florida. The AG has sent letters to all law enforcement agencies letting them know you can open carry in Florida, but it was official on the 25th, which I still have a case against the state of Florida, which hasn't been mooted. So
I hope it doesn't get mooted.
I hope it doesn't get mooted. It'd be fun to be part of that, like Dick Heller, because I like Dick.
Well, okay. Yeah. So basically, this is what we expected.
Cool.
The government has a couple different choices here. First thing they can do is not appeal and just let it die, which I don't see them doing. Or they can appeal to the Fifth Circuit Court of Appeals, which I do see them doing. I don't think that the Fifth Circuit is going to fine for the government just because of what the Fifth Circuit does. But if it does get a Fifth Circuit, if they do appeal, it will go to a 3-judge panel. And I don't think there's any 3-judge panel from the Fifth Circuit that's going to fine for the federal government in this. But who knows what the court's going to do. Then after that, they can go en banc, which is the full bench, or they can go directly to SCOTUS through a writ of certiorari. En banc means the full bench will hear the case, and that means that the panel decision would be vacated, like it never happened. But it has to get to that panel decision. What the government can also do is they can ask for an administrative stay, an emergency administrative stay on the ruling, because right now the law is dead. To as applied to members of the organizations named.
Which means you could mistakenly be arrested and have a freaking hard day and get your gun confiscated, have to fight to get it back and go to court. So probably good idea not to do it yet until the memo goes out. And if it goes out by mail, it might be a while.
But what they can do is they can ask for an administrative stay, an emergency administrative stay on the ruling, which would basically hold it up until the circuit court could review it. Now they could ask for that, and I could think they probably will ask for that. I don't think that the Fifth Circuit is going to grant that, although that they could. But I just don't see that happening.
Now, would that go to Reed O'Connor? Would that be for him to say yay or nay on?
Well, they can go directly. They can go to him and ask for him to stay his decision, or they can go to the circuit court. I don't think he's going to stay his decision, though.
So this is interesting because this is some hot topic in Florida. Places can put up no firearms, allowed in their business. Technically, the sign doesn't mean anything. They can ask you to leave, and if you don't leave, then that's armed trespass, and that's a felony. That's a bad thing. So I guess the post offices can't have any no gun signs because
they can take it down. They don't have to take it down right now because it's only as applied to.
So historically, that's something that crossed my mind while I was reading it. What has happened in as applied cases to classes of people, meaning like GOA members, SAF members, FPC members, that kind of thing. Because these organizations do not share their membership list, they're not compelled to do so.
I was about to go there.
An officer can't clearly say, I'm arresting you because you may or may not be an FPC member.
It's on the honor system.
So
it's
effectively, when it's a large class of people like this, effectively when it's a large class of people like this, it kind of means it applies to everybody.
For example, the pistol brace thing only applied to GOA members originally. But because that's millions of people and GOA doesn't have to share their stuff, injunction de facto applied to everyone. Now that's taken care of, and it's not really. I mean, it's that rule is dead. But originally, it applied to only JOA members. But since they couldn't determine who and who was not a JOA member, that
Yeah, we don't smell different, so
yeah, they couldn't really. They really couldn't enforce it, and they're not going to be able to enforce this either. Yep.
interesting.
All right. Well, that is it, guys. Thank you so much. Remember, we are raising money for Pack 997 of the Scouts. The Scouts is a great organization. The Pack 997 is a conservative troop that pushes conservative pack that pushes American values. It's an all boys pack, really God focused, like religion focused. And we can use your help. Scouting is expensive, and your donation can help more kids learn about scouting from a conservative traditional pack. And it can help them develop life skills that they will use for the rest of their lives. And it would just help out anyone. And also, if you own a company, we can work out a sponsorship deal where 100% of the funds will go to scouting for whatever I bring in. And you get ad reads and everything else. So if you want to do that, just go to givesandgo/997, givesandgo.com/997, and donate some money today. And I'll love you a long time. And with that,
I sent a message to, actually, Sierra sent a message to me today. I replied. So
Nice.
he's going to be out, as far as I know, early December.
Yeah, that's what I'm hearing. I didn't know that. I thought that was a secret. I thought they wanted to announce it.
Oh, did I blow it?
I think you did.
I don't think I did.
I think you did.
Uh-oh. Don't tell anyone. There's only 170 of us here.
I'm pretty sure you did, Rich.
Ruh-roh.
Thought Erica wanted to announce that on her channel, but okay.
I thought she announced it weeks ago.
Maybe she did. I don't know. All right, guys, that's it. See you guys later. Have a great day. Bye-bye. Bye-bye.